Hello and welcome to Runkle to the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk a little bit about the trial of Scot Peterson, which has just begun. Now, if you don't know who this is, he was stationed as an officer at the Parkland school where the shooting took place, and he's being charged with a number of offenses basically relating to a failure to act. And so essentially they want to say that he had a duty to intervene and to try to stop the shooting, and he didn't, and therefore he should be held liable. Now, I wanted to highlight some of the conduct or the performance of the defense lawyer because there was a moment in today's trial where I thought he did really well and a moment where I thought he did not so well. I actually thought he did quite poorly at this particular moment. So we're going to look at those two moments, and we're going to start with the one where I thought he did not so well. Now, I just want to note here, people love to leap to conclusions. Just because a lawyer had a bad moment or a good moment in a trial doesn't mean that they're going to win. And it doesn't mean that they're incompetent or inept or anything. Every lawyer makes mistakes. Every lawyer has good days. This is early on in this trial, so I'm just offering that as a caution. All right, let's go and have a look. This is the tail end of the defense lawyer's opening statement. So keep in mind, this is the last thing that's happening as part of his opening statement, and therefore what the jurors are most likely to remember as the tail end of his opening statement. And the issue he runs into is that an opening statement, you can outline your case, you can outline what the evidence is, but it's not a place to make argument. That's for the close. So he's limited as to what he can and can't say, and he runs afoul of that in a way that I think is not great. I was going to say it's going to cause him some problems. It might get him to lose a little bit of credibility with the jury, but it's not going to be fatal. It's just a not great moment.
That's the perjury count. Detective Curcio will tell you that he never then asks my client, how many total shots did you hear from beginning to end? He will tell you, yeah, I didn't think that question was necessary. That's the perjury count. The second part of the perjury count is they claim that my client saw some kids leave the 1200 building. While my client's on his radios, while he's telling kids in the 700 building stay back, while he's doing about a million things with the stress of the world on his shoulders.
Objection argument.
Yeah, that's sustained.
The other
Yeah, the problem there is that you can talk about, the evidence will show that my client was, and ideally you should be saying the evidence of a specific witness. Like, you will hear from this witness who will say that it was a stressful scenario and that my client was doing a lot of different things. Uh, but you can't frame it as argument here. You can't frame it the way he's doing it. So that's where he's running into trouble, and that's why that objection was sustained.
evidence will show that they're claiming my client didn't see kids running out of the 1200 building. I'm quite certain you will not see any video of those kids actually leaving. I would imagine if they're representing it that kids did leave the 1200 building. He told Detective Curcio he didn't see kids leaving the 1200 building. There will be no evidence that those kids ever came up to my client or had blood on them or something to indicate that they need to be spoken to or investigated. The evidence will show he didn't lie about that at all. Another charge for which he did not commit.
Objection argument.
Yeah, that's sustained, Mr. Aguilar.
Amended.
Because of your continued objectionable comments, I'm going to ask you to conclude your opening statement at this time. Go ahead, sir.
I'm concluding, ladies and gentlemen.
This is why this is bad, because ultimately he's being told, hey, you've made so many objectionable statements here that you need to wrap this up. You're not allowed to continue your close. And he was already trying to wrap up his close. That's what he was doing here. But now he's being told by the juror, like in front of the jury, he's being told that he can't continue. And so the jury's going to remember that the judge told him to stop that. The judge basically said that's not okay. So that's not an impression I'd want to leave with the jury. Let's watch the last little bit here because they wrap it up fairly quickly.
The evidence will show that my client did not commit any of the offenses alleged. He was sacrificed and thrown under the bus.
Objection argument.
And
Yep,
the
that
only-
is sustained.
And the only verdict in this case, ladies and gentlemen, thank you for your kind attention. The only verdict that speaks the truth in this case, based upon the evidence, is not guilty. Thank you.
All right. So, I mean, he recovers and he manages to wrap it up. He gets us to a sort of decent closing point, but I wasn't really thrilled with how he went about getting us there. I wasn't really thrilled with this, with basically wrapping it up in such a fashion that the judge has to tell him, again, in the view of the jury, you had too many objectionable statements. You have to stop. Because now it doesn't look like he's stopping as much at a place where he wants to. He looks like he's being told that he's got to stop. You never really want the jury to be given an impression that you are behaving badly, because credibility of counsel is actually a bit of a thing. It's a bit of a challenge. You want the jury to think that you are there to help them out, and that you are somebody they can trust and rely on. That's always hard for defense counsel to get to, but you don't want to blow it up at the start of the trial. All right, so now I wanted to look at a moment that I thought defense counsel did quite well, and this is the cross-examination of the first witness. Now, this first witness was a student at the Parkland at the shooting, and in fact was in a room that was shot into, and she saw one of her classmates die as a result of that. So this is a very sensitive witness. It's a very you got to be very careful with a witness like this, because it could go quite badly. And I'm not going to show you the full direct here because I'm trying to keep this video a little shorter, but they didn't go into many of the lurid details. So we'll just have a look at this cross-examination, and then I'll tell you why I think he did a good job here, what I think was good about it. All right, here we go. Getting ready to go? Here we go.
Hello.
I'm very sorry that you endured what you did. I'm going to be extremely brief, I promise you. Just a few questions.
Starting with compassion is a good point.
Crystal clear, it's on the first floor of the 1200 building, correct?
Yes.
And the shooter was on your floor when we're hearing at least the initial shots, right? They were very loud. He was on your floor.
Mm-hmm.
Is that a yes?
Yes, correct.
And there's no question that he was inside the 1200 building, and you were also inside the 1200 building when you heard those shots, correct?
Yes.
Now, the reason why he's going in this direction is he's trying to establish that maybe, his client who was outside the building couldn't hear as well, right? And you see that he's asking very, very pointed questions. He's keeping this witness on a particular topic. He has to clarify when she says, mm-hmm. He says, that's a yes, right? And he does it very smoothly. So far, everything's going really well here.
And I think you testified that the sounds slowly decreased and we couldn't hear them as he moved throughout the 1200 building, correct?
In the classroom that I was in 1213, once he went up a couple of floors, like to the second or third, then it died down, yes.
Correct. And there were times then that he would be shooting that you couldn't hear him based upon where you were located, correct?
Yes.
That's a fantastic answer for the defense here. That is really what he wanted to get this witness to say. So that's a fantastic answer for them at this point. Let's keep going, and then I'll talk about why I think he's doing such a great job. It's actually not so much what he says as what he doesn't do.
And you have no firsthand knowledge at all about what he was going through, what he was encountering, where he was located, correct?
That day, I was not sure.
Okay. Again, I'm very sorry that you had to go through this. I wish you the very best.
Thank you.
Okay, based on that, any redirect?
No, Your Honor.
Is the witness excused?
Yes, yes.
All right, you may step down. Thank you very much.
So, he finishes up again, finishing up with a bit of compassion. He's basically empathizing with the witness, which is a good thing to be doing, at least in this case, because this is not a witness that he wants to come off as attacking. He doesn't want the jury to see his client who, keep in mind, his client here is, a police officer, is an officer, and is not, the argument isn't that his client was actually going out and committing the shooting or involved in it. It's an argument of inaction. And so he doesn't want to attack this witness. He doesn't need to destroy her evidence. He just needs to clarify it. But keep in mind, this witness is a potential hand grenade in this courtroom, because it would be really easy to get this witness into a place where she's crying, where she's reliving trauma, where she's, where she's saying something like, I saw one of my friends die in front of me, any of these things. And instead, he gets what he needs from this witness in terms of some really good, clear admissions that maybe it would have been hard to hear at different points. And then he stops asking questions. The best thing about this, and this is actually surprisingly difficult, is just to stop asking questions at the right point. And in this case, I think he really nailed that. So right now we're at early stages of this trial. I'm not going to make a prediction at this point because we're too early in. But there's moments that I thought the defense lawyer dropped the ball, but I was impressed by this cross-examination and, in fact, by some of his other cross-examinations. So I think this is an interesting one. I'm going to keep paying attention to it as I can. And yeah, I'll keep sort of giving some updates, maybe do some trial recaps when I'm able to, and we'll go from there. So let me know if this is one that interests you. I hope so, because it's been interesting to me, and I think it's going to be an interesting question as to the potential duties and potential liabilities of officers in various situations to address this. I'm probably also going to do a video, and let me know if this is something that interests you as well, but talking about the International Association of Chiefs of Police and their protocols that they recommend in terms of dealing with these kinds of situations, and basically why those protocols exist. So thank you for watching. I hope you found this to be interesting and educational. I think this is going to be a really interesting trial with some really interesting legal and factual issues. So please hit the like button, subscribe if you want to see more content like this, share this with your friends. I also want to thank my Patreon supporters at the $50 level, the CCFR, CAIM, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Jane Babin Luxor. And at the $20 level, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Gerald to the Bailey, Cameron Johnson, Andrew Elsich, Vicky, and Brigitte Edrup. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. I hope this has armed you with knowledge. See you next time.